And then I will unmute you. Okay. And whenever you are ready, then we can begin. Okay. Go. Okay. Good morning, everyone. You are all very welcome to today's webinar. This is actually webinar number 2 in a series of webinars that we are doing focused on the sports sector. My name is Rachel Kavanagh, and I will be moderating today's webinar, which basically means I'm the chief timekeeper. So we are going to try and pack as much as we can in, but we are very much focused on trying to get through it in the hour or as close to the hour as we can. So our aim today is to provide some useful insights, some guidance, and we're hoping some practical tips on topics that you may be dealing with in your sports organisation on a day-to-day or a week-to-week basis. So today we're going to cover areas such as employment law, data privacy, and the ever-important topic of good governance. So I'm delighted to be joined today by 3 of my MHC colleagues. We have Catherine O'Flynn from our employment team, Micheál McCarthy from our data privacy team, and Nick Metcalf from the corporate governance team. So to some degree, I'll be a bit of an audience member today as well. Outside of work, I'm very involved in sports organisations. On the governance side of sport, I'm the chair of a football club. So I am very involved in drafting policies and dealing with discipline issues and all of the kind of regulation around sport. So I'll probably be chipping in with my lots of my own questions today. So let's try and use the hour as best we can. And let's maybe start with Catherine and the area of employment law. So maybe, Catherine, you could remind us of some of the various types of employment contracts and arrangements and what those contracts should contain.
Yeah, certainly. Hi, everyone. Thanks for joining us. So first of all, we'll do a quick refresh over what contracts of employment should contain. So we all know you can have a contract of employment verbally, but it's always best if it's reduced to writing. And there are certain particulars that must be in the contract of employment. So the first one is under the Terms of Employment Information Act. So actually within 5 days of the employee starting, you do need to give them certain basic info, like the name and address of the employer, their rate of pay, the hours, the expected duration if it's short term. And then within 2 months of commencement, there is another list that you must give to your employee. And that covers kind of more meaty topics like their title, place of work, how they will be paid, any arrangements around paid leave, like maternity leave, something like that, and any arrangements in relation to sick leave or pensions. So as I said, that has to be given within 2 months. So what we would always say to our clients is that best just to give it before they commence and give all that detail in one written document, and then you'll have covered yourself off. And also worth noting that the Unfair Dismissals Act requires employers to give a copy of your disciplinary policy to your employees within 28 days of commencement. So that's a good one to remember as well, actually.
And people should also presumably be conscious of the various types of employment relationships. So
yeah,
give us a summary of those.
Absolutely. So I guess the main one would be kind of the open-ended relationship that you might enter into with your employees. So that's where you enter into a contract of employment and it doesn't end until one party serves notice on the other. And that generally would have a probationary period. And once the probationary period successfully passed, employees and employers kind of consider that to be permanent employment at that stage.
And I know from speaking to you previously, there have been some recent-ish changes in relation to probationary periods.
That's right, yeah. So they've actually, the changes came in October 22, but some employers are still just getting familiar with it. So actually, the law now is that you can't have a probationary period for longer than 6 months unless it is in the interests, choose quotation marks, of the employee and in exceptional circumstances. So what is in the interest of the employee has yet to be tested by any court. But what we take it to mean is that it generally is in the interest of the employee to extend rather than end their employment. And when we talk about exceptional circumstances, they don't apply to the individual employee. It just means that the employer shouldn't be extending as a matter of course. So don't be extending all the time. Consider whether you actually need to extend.
And what's the position in relation to exclusivity clauses? Are there new rules around that? People should be conscious of?
Yes, and I think that maybe comes as a surprise to some employers too. So you can't, as a starting point, you shouldn't have an exclusive service clause in your contract actually. But that said, there is a saver. So if it's very important to the employer that they don't want their employees working elsewhere during the contract, you can, as long as you write it into your contract and you have an objective justification. So those kind of justifications would be something like health and safety, protection of business confidentiality, integrity to public service, and a big one would be avoidance of conflicts of interest.
And what is the situation in relation to, say, temporary arrangements?
Yeah, because I think sporting organisations will often have people in on temporary arrangements. The biggie would be fixed term contracts. So you're probably all really familiar with fixed term contracts, but just in terms of a few pointers, I guess important to note that you cannot treat your fixed term employees any less favorably than your your permanent comparable employees. If you do have a probationary period, going back to that, it should be proportionate to the length of the term. A very important rule is that if you have 2 or more successive fixed term contracts, they shouldn't go longer than 4 years. Otherwise, you're running a risk of that employee gaining permanent employment status inadvertently. You should still have a notice provision in your fixed term contract, even if it is going to end on a certain date, in case you need to terminate early, maybe because of misconduct or redundancy. And perhaps most importantly, the Unfair Dismissals Acts shall not apply to the expiry of the term, as long as you state that in the contract and it's signed by both parties. So that's another important thing to bear in mind.
And Catherine, is there a requirement for a fixed term contract to be any particular length?
No, actually, it can be as shorter as long as you want. Just bear in mind the rule about successive contracts not going over 4 years. But if they're not successive, you could have a first fixed term contract for 10 years if you need it.
Very helpful reminder. So we've looked at different types of contracts. Could you maybe just give us a rundown now of the different types of employees?
Yeah, certainly. So you could have obviously your permanent employees we've discussed. You might have part-time employees working with you, so they obviously work less hours than the permanent employees. Again, they shouldn't be treated any less favorably, so their terms and conditions should be prorated. Sporting organisations will often have casual workers. So, for example, you might need a medical practitioner at a Saturday match, so they might be employed on a casual basis. You could have seasonal workers for a tournament, say, for example. You might have agency workers who are employed by the agency itself rather than the end user. So there are different kind of classifications, but bear in mind that, they will have employment rights. And so just make sure they're papered correctly and thought about properly.
And I think a lot of people in the audience, including myself, will wonder about the status of volunteers in the context of all that.
Yeah, definitely. So I think that's a big topic for sporting organisations, certainly. And, there may be some volunteers on the call as well. So volunteers obviously carry out voluntary work without an expectation of salary, perhaps except for reimbursement of expenses. And maybe a good example of that might be stewards at a match day, for example. So there are no employment rights conferred on volunteers. So that means if you do not need to use them anymore, they cannot claim under the Unfair Dismissals Act. But there was a case worth noting, which involved Camp Hill Communications. And that was a charity that worked with people with disabilities. And they had an individual who volunteered or joined with them in 1994 and stayed for quite a long time, up to 2018, and then her services were no longer required. And she actually brought an unfair dismissals claim to the WRC. The charity said, well, no, because you're a volunteer, so you can't bring a complaint of unfair dismissal. And in their support, they said she was providing her services voluntarily, she wasn't paid a salary, there was no contractual relationship there or intention to create a contractual relationship, but actually the WRC found in her favour. So they appealed that to the Labour Court, and again, the Labour Court found that although she didn't receive kind of a regular salary, she certainly received more than just reimbursement for expenses. So, for example, she did receive annual leave, she received travel, accommodation, education and medical expenses even. So another important thing was that she couldn't just decide not to volunteer on a particular day. There would be consequences for her if she didn't. So clearly they had just kind of overstepped the line. And the Labour Court said the only difference really between her and the employees was the way she was paid. So I think that's very important just to remember for everyone on the call, that, you know, a wage or a salary isn't the only thing that's going to be indicative of whether someone is an employee. And once that person is deemed an employee, obviously they have much more rights and entitlements.
Yeah, I think that's a very important thing for all of us to remember. And maybe one of the takeaways for us today is to think about the volunteers we have in our clubs and our sports organizations.
Yeah.
And think about whether they have veered into the territory of employee, because obviously there is a distinction and certain things will flow from that. So I think that's a takeaway. I think the next topic we want to cover is the difference between employees and contractors, which I know we touched on in a previous webinar, but you're going to give us a summary and an update on that.
Sure, yeah. So we've talked about the various different types of employees and employment relationships. Self-employed individuals, then they tend to own their own business, work on their own account. They can maybe even subcontract their work their own hours. So that's sort of the distinction. But that said, those boundaries or that distinction, as we all probably know, can sometimes get blurred. And it's not as simple as just putting a label on it, you know, calling someone an employee or a contractor. And we've seen lots of instances where either the Irish Revenue or the WRC will have to step in and say, actually, no, that person was misclassified. And then that can have repercussions in terms of employment rights being imposed or tax liabilities as well, of course. And as you say, this was brought up on our last webinar. We mentioned the kind of seminal Supreme Court decision in the Domino's Pizza case. So that involved a case as to whether the Domino's pizza drivers were contractors or employees. And the Supreme Court in that case issued really important guidance via a 5-step process, which is to be followed to determine whether someone is an employee or a contractor. And I'll just run through the 5 steps really quickly because it's important, I think. So first of all, is there an exchange of a wage? If so, is the contract one where the worker is providing the services themselves personally? Thirdly, does the employer exercise sufficient control over that worker or the employee? And if those first 3 requirements are met, then it must be determined whether the terms of the contract and the reality of the working arrangements are consistent with an employment contract or otherwise. And then finally, are there any legislative framework matters to be considered? So that's the 5-step process.
Yeah, I'm good to get that reminder. Have there been any developments since that Supreme Court decision?
There have actually. So again, the reason why we brought it up again, so since that, then the Revenue issued guidance to kind of affirm that 5-step test. And so we would really highly recommend that all sporting organizations get familiar with that 5-step test and look to see whether anyone is potentially misclassified. And then additionally, actually, as recently as October of last year, the Department of Social Protection and the WRC issued guidance in the form of a code of practice. So that confirms that the 5-step test in the Carshan Domino's Pizza case is not only important from a taxation revenue perspective, but it will also be taken into consideration by the WRC from an employment perspective as to whether someone is an employee or a contractor.
So something we all need to be conscious of.
Yeah.
Very helpful refresher, Catherine. Thanks for that. And we are now going to turn to the very topical topic of return to work. So it's in the newspapers a lot. We've seen a lot of talk about it. So can you talk us through some of those issues and what people should be aware of in what we're calling the call back to the office?
Yeah, definitely. So yeah, as you say, like we're reading about it every day. There is lots of talk about big employers calling their workers back to the office 5 days with varying degrees of success. So from our perspective just today, I just want to touch on the kind of legislative framework. So there is legislation. It's the Work-Life Balance and Miscellaneous Provisions Act, very snappily titled piece of legislation. And that actually provides employees with the right to request remote work, but I think we're all familiar with the fact that it doesn't provide employees with the right to remote work. You can request it, but there is no obligation on the employer to grant it. That's kind of the message that we're all getting familiar with. So from the employer's perspective, once they follow the process that's set out in that act and also in another WRC code of practice, they can be fairly confident that if they were challenged, they will be able to defend any such challenge. So the process very at a high level, you have 4 weeks to either grant or refuse a request. If you need more time, during that 4 weeks, you can tell the employee that you need an extra up to 8 weeks to consider the request. And so really the organisation should consider the request in an objective, fair and reasonable manner. And if it's not feasible, they should consider alternatives as well, and make sure that they keep a written record of every stage of that decision-making process in the case of a challenge.
And then with remote working, if we're looking at from the employee side,
Yeah.
what can you tell us about that?
Yeah, because we kind of sort of focus on the employer side. From the employee side, this is their big opportunity to request remote work. So I think they should familiarise themselves with the code of practice also. They should think about why they're requesting it. Is it to reduce their commute time? Is it to improve their work-life balance? Are there other personal circumstances? And then think about, do they have a good workspace at home that's confidential, that's secure? Do they have good internet connectivity? Are they close to the office? Do they appreciate that there may need to be flexibility there in case they need to go in at short notice? And then that will give the opportunity, the employer the opportunity to balance that against their interests. And then, as I said, if the employer accepts it, they set that out in writing, they come up with a written arrangement. And if in doubt, I think a trial period could sometimes be a good idea.
Yeah, good advice. And if an arrangement is put in place, presumably it can be altered, can it be terminated?
It can both, actually. Yeah, it can be altered by agreement and it can be terminated by the employer if there is adverse impact on the business. And in which case they would need to give the employee 4 weeks written notice of that.
And I think people are going to be seeing more and more of these issues cropping up.
Definitely.
And another useful summary of that. So I think the final topic we're going to deal with today is a topic that you're seeing an awful lot more with clients in all kinds of sectors, which is the issue of whistleblowing complaints.
Yeah, definitely. So yes, as you say, we're seeing this on a daily basis. So this is governed by the Protected Disclosures Act. The main message, I think, for everyone on the call is that anyone who makes a protected disclosure or who is a whistleblower, more commonly known, they're protected by law. So effectively, they shouldn't be treated unfairly or lose their job because they've made a protected disclosure. And from a sporting organisation perspective, again, it's worth noting that protected disclosures can be made by a wide range of people, not just your kind of regular employees. They can also be made by board members, agency workers, volunteers, back to our volunteers. So the definition of a worker is very broad in the legislation. In terms of what is a protected disclosure, it's a disclosure of relevant information that the worker reasonably believes tends to show a relevant wrongdoing, and it came to their attention during the course of work. And what is a relevant wrongdoing? It's all set out in that legislation. There's 9 examples of what could be a relevant wrongdoing. So I won't go into them all, but they're things like criminal offences or damaging the environment. From an employment law perspective, there is a couple that are important, which would be a failure to comply with a legal obligation, because that could cover bullying if it's endemic in the workforce, and also endangering the health and safety of individuals, because that could actually cover, a myriad of health and safety issues that employees might bring up. So if it falls within any of those 9 examples, that could be a protected disclosure.
And let's flip it then. So what is not a protected disclosure?
Yeah, so that's important, I think, for employment, from an employment perspective, certainly. So it won't be a protected disclosure if it just relates to the worker's own contract. So if I have my own issue that doesn't impact upon anyone else, it's unlikely to be a protected disclosure. And similarly, if it's actually part of my job to detect that wrongdoing, that would not be a protected disclosure either. Yeah. So I think just kind of in terms of main points to note, cases are on the rise. I think there was like a 200% increase in the last year in these types of claims for the WRC. That said, kind of about 80% over 80% are unsuccessful, actually. So they're hard cases to bring home. But if a sporting organisation has over 50 employees, they are required to have an internal channel in place to enable workers make these allegations of wrongdoing. So it's really important to have a policy in place.
Policies
For sure. And keep records of any of these complaints. And again, back to the start, just make sure that a worker who makes such a complaint isn't penalised, because the compensation can be up to 5 years rather than 2 years, which is the norm.
And so then what is the position if an investigation then flows from a whistleblowing incident? So what does that look like?
Yeah, so they're tricky investigations, no two ways around it. So the first thing would be to decide if it is a protected disclosure or isn't, in terms of what we spoke about. So you kind of have an initial assessment. If it is, you have to go through a very thorough investigation. If it isn't, perhaps it can be closed, or perhaps it should be directed to the grievance policy if it maybe deals with something that's personal to the employee's contract. And then just a couple of things to note. If someone has made an allegation of wrongdoing, they are supposed to be acknowledged within 7 days. And then there is a requirement to keep them updated during the course of that investigation at 3 monthly intervals. So kind of a couple of things just to bear in mind.
Very, very useful. And I think a bit like the remote working, I think we're going to see more and more of this.
Definitely.
You're seeing more of it in your day to day. I think it's going to come into that kind of sports area. So a very useful summary all around, Catherine. So thanks for that. We are now going to turn to Micheál. And Micheál, you are going to deal with the issue of, I'm going to have to decide if I'm calling it data or data. That'll be my first job for today. We're going to turn to the issue of data privacy. We're going to try and make it really specific for sports organisations if we can. So last year, the Data Protection Commissioner did a survey of sports organisations. And I think you're going to deal with what came out of that and deal with all of the kind of topics that arose in that. So maybe we could start off for people like me and tell me, what is personal data?
Sure, Rachel. So firstly, I guess sports clubs will collect personal data about players, members of the club, employees of the club. So personal data will typically include things like your name, your address, your date of birth, gender, if you have particular health issues, and for players, it will also include performance data. So back to this survey the DPC conducted. So basically, it carried out the survey back in 2024 of approximately 100 sports clubs. So the results, which were published in December, are interesting, but also they reveal significant compliance gaps in relation to the GDPR. So the key findings that came out of the survey, which I'm going to talk about, were in relation to data protection policies and procedures, data retention, performance data, data protection, risk assessments, and finally the use of personal devices by club committee members and coaches, etc. So maybe to start with data protection policies and procedures. So interestingly, 41% of clubs, and that is 2 in 5 clubs, stated that they don't have personal data protection policies and procedures. So these types of procedures are really important for clubs to ensure they comply with the GDPR. So to mitigate this risk that they're exposed to, clubs should document the policies and procedures in relation to data protection, so that staff and committee members are aware of their responsibilities in relation to personal data. So these types of policies could include, for example, telling staff, what do I need to do if I receive a data subject access request, or what do I need to do if there's a personal data breach? So in addition to documenting these policies and procedures, clubs also need to provide training to relevant staff members to ensure they're aware of these policies and procedures that are relevant to their role. So
Can I jump in with a question?
Yeah, sure.
Okay, just from my own point of view, I'm trying to think. So for smaller organizations, say if we're talking about a club, is it a good idea to task a particular person or particular people with kind of oversight on the data privacy issues? Does that mean then that it'll have a particular focus within a club? Does it mean that people get a chance to, suppose, increase their knowledge, and hopefully that will lead to kind of better compliance? Is that a kind of a good practice?
Yeah, absolutely, Rachel. And I suppose it depends on the size of the club, but at a minimum, there should be one person, who maintains oversight and has responsibility for ensuring data protection compliance within the sports club.
Okay, so once again, back to the issue of policies as well. So give the job to someone, help them understand what they have to do, and then have your policy in place. I think the next subject or the kind of next area that was dealt with in the results, survey results, was the issue of data retention. So could you give us a summary of what came out of the survey?
Yes, and the results again here were very interesting. Over 51% of the clubs which were surveyed stated that they didn't have a data retention schedule or a data retention policy. So the risk here is that sports clubs are keeping personal data about members and players for far longer than is necessary for the purposes for which the personal data was originally collected. If we take the example of membership data that's collected about a member, for example, Rachel, if you become a member of a club, you provide your name and your address, your contact details to the club. But then 1 year later, you decide to leave the club. So at that point, the club should have a policy in place to delete the data they hold about you, unless there's some specific reason that they need to hold it for a longer period.
And presumably that policy in relation to how long you hold data and getting rid of data you don't need anymore, that should all be dealt with in your data privacy policy?
Yes, it can be included in your data privacy policy, and the DPC seems to recommend that you should also have a separate schedule listing out all the types of personal data that you collect and the retention period that you're retaining the various types of data that you hold.
Yeah, and I think another thing sports organisations and clubs should be conscious of as well, and again, I've come across it in my own experience, is if a committee member ceases to be involved with the club, or a coach ceases to be involved with the club, I suppose it's to be conscious of what data they may have in relation to club members and players, and maybe have a process in place where when they leave that they have to get rid of all of their whatever data they have and return it back to the club.
Yes, that's absolutely correct, Rachel. And this is one of the points the DPC picked up in its survey, and the importance of having policies to deal with scenarios where club members leave the club, but they may have, for example, personal data about club members on their laptop or their personal phone.
Yeah, something my head is going here. Yeah, look, it is something that we all need to be more conscious of. So I think the next topic we're going to deal with is the topic of what's called special category data. And I think for our purposes today, we're going to think about that in the context of, or in terms of, health and performance data. So it does have a broader definition in the legislation, but for our purposes, if we can limit our thoughts to health and performance data. So how was that dealt with in the survey results?
So 56% of clubs surveyed reported that they didn't collect health data. However, 39% of clubs, or approximately 2 in 5 of those clubs, stated that they collected performance data about players. Now, which you will be, from being active in the club, you will be familiar of the various technologies that are now in place to collect performance data from players. Not only during training, but in competition. Typically, you'll see use of these GPS type tracking. So basically, if a club is using this type of tracking for their players, so it opens up the potential that they're collecting vast amounts of data about their players. For example, their running speed, the distance they've run, their position on the pitch, their heart rate, and their body's work rate. So the DPC basically stated that if clubs are collecting this type of data from their players, that if it's collected over time, then there's a strong likelihood that they are collecting health data because it's giving information about the player's physical health-being. So basically, then if the club is collecting health data, as you mentioned, it's a special category of data under the GDPR and has special protection. And the starting point for special category data is that you're prohibited from processing it unless a specific or special condition applies. For example, obtaining explicit consent from the players in this case to process their performance data.
And you mentioned express or explicit consent. Would it be good practice to maybe look for that consent, maybe as part of a membership renewal process? So I think a lot of people do that online now on these kind of external platforms. So could you build in a specific consent into that process so you're getting that consent every year, provided of course that people are being told exactly what data has been captured and what it's been captured for?
Yes, Rachel, and you mentioned two key points. So basically providing information to the players about the performance data that you're collecting about them, and also what you're doing with that data and how long you're keeping it. And yes, a really important point is that you obtain that consent before you actually start collecting that data.
Yeah. And just one of my own observations is, I mean, if you're going to ask people for data, it's important that you look at it and you read that data. And to understand sometimes the significance of data can change depending on the context you're in. So for example, if you're asking players for information about, say, food allergies, which might not be relevant for an hour's training session in midweek, but it could become very relevant in the context of a trip away or an overnight. So just make sure that if you're asking for the data and you're keeping the data, that you're looking at it and that you understand how it's to be used and when it's to be used. So as I say, the relevance of that data can change. So the next topic, which sounds quite daunting, but hopefully, as I say, you'll demystify it for us, is the issue of data protection impact assessments.
Yes, Rachel. Data protection impact assessments, or DPIAs, was one of the interesting findings from the DPC survey. So basically, only 9% of clubs reported that they carry out a DPIA. So what is a DPIA? So essentially, a DPIA is a process which is designed to identify risks which may arise from the processing of personal data. And an important point to remember is that a DPIA is only mandatory where the processing of personal data is likely to result in a high risk to the individual whose personal data you're collecting. So the DPC raised the issue of clubs processing performance data or potentially health data. And basically it stated, or it recommended, that clubs who are collecting this type of performance data about players should carry out a data protection impact assessment in relation to that processing. So this is one of the key takeaways from the survey. Now, as you mentioned earlier, Rachel, data protection impact assessments can be quite daunting and challenging for most organizations, and in particular for clubs that may not have done one of these before. And this is one of the areas, I guess, in NHC that we frequently work and help organizations document their data protection impact assessment.
And I think people will be kind of conscious, or they'll know about risk assessments in the context of health and safety. So it's not a kind of a dissimilar process. I've written down just a few points here. What you're effectively doing is you're assessing what data you have and where you have it. You're trying to assess the possibility of something going wrong in terms of having that data. So you've got the wrong data, or the data gets to a third party, or there's a data breach. You're assessing the impact that that's going to have on the person whose data we're talking about. And then you're trying to put those safeguards in place. So if you think of it as those 4 steps, would that be helpful?
Absolutely, Rachel. Yes.
And I think there are resources available on the DPC website, so the Data Protection Commissioner's website has lots of good stuff there as well. If
That's
people want
correct.
to look at that.
There's lots of really good resources out there, and indeed the governing bodies and various organizations like that have good resources as well to support
exactly. So they should be
organizations.
exactly. Don't let it be too daunting. There are lots of resources out there that kind of talk you through the process. So the next topic that was dealt with in the survey was the issue of security. So can you give us some highlights of what the survey results showed?
Yes, and the results showed that 1/3 of clubs stated that their staff and volunteers use their personal devices to manage and to access personal data relating to players or club members. So this is obviously not ideal, and it creates risks for the sports club in relation to the security of the personal data of their members and players. Now, the DPC did recommend that clubs should consider putting in place what they call a bring your own device policy to set out safeguards that club staff or club volunteers comply with when they're using their personal laptops and devices. For example, things like what security measures they should have placed on their laptops or their phone. What happens when the club committee member or the staff member or the coach leaves the club, how the personal data is going to be deleted. So these type of measures to provide protection to the personal data. And another issue that's probably quite common across sports clubs is the use of personal emails and work emails when conducting club business, and particularly in relation to the personal data of members and players. So the DPC basically said that the use of personal emails or work emails does not require or does not meet the required security standards. So again, this is another key takeaway for clubs to address in order to mitigate the security of personal data.
And I suspect that this is where there's going to have to be a lot of work done by sports clubs. So again, we're talking about relatively simple steps, which is try and set up your dedicated club email account. Make sure that any devices that have personal data on it, that they've got their virus protection and so on, just add that layer of security. Try and restrict access to those devices. Meal, I think, is probably a key feature of this as well. And then for that kind of super sensitive data, if we can put it that way, think about your password protection. So even to put those 4 steps in place, I think would get you a good bit on that journey towards, kind of decent levels of security.
Yes, absolutely, Rachel.
So we're going to turn to the final topic of transparency. So I think this was the final area that was covered in the survey results. So again, what did the DPC see out of the survey results on the issue of transparency?
So more generally, yes, transparency is really important to ensure that club members and players know what information is being collected about them, what the sports club is doing with that data, what the legal basis is for processing the personal data, who the information may be shared with, how long it's being stored for, and how players and club members can exercise what we call their user rights under the GDPR. So typically, clubs will make this type of information available in a privacy policy or a privacy statement, and this is usually accessible on the club's website.
And I think one of the key principles of transparency is that entitlement for someone to get copies of any personal data that an organization holds about them. That applies in the kind of sports context as well. So I suppose people should be aware this is where the rubber hits the road in terms of knowing what data you have, but more importantly, where that data is. So if you get what's called a subject access data request from someone, and you are the person dealing with that inside the sports organization, that you can go through the process of trying to gather that data so that then you can comply with the request. So that's what comes back to the importance of knowing what data you have and where the data is kept.
Yes, Rachel, and the what we call the right of access or data subject access requests is probably one of the GDPR rights that people or that individuals exercise most frequently. It can be quite onerous for and a tortuous process for most organizations, but you can, I guess, have steps in place to make the process easier and facilitate your response within 4 weeks to that request. And again, going back to the importance of having a procedure in place to outline the various steps that you need to go through to respond to that access request.
And probably worth reminding people that if somebody is mentioned in a WhatsApp or an email or a text message, and a DSAR, a subject access request is made, that they may be entitled to copies of those emails and text messages and WhatsApp. So it's just something we see that a lot in the kind of in the legal world. So just be conscious of that in your context as well.
Yes, Rachel. And again, I suppose that particular issue ties into when people are using their own devices. It just makes the process of responding to an access request more complex.
So be good to yourselves in terms of the way you keep and store data. So Micheál, what's next? I suppose is the big question. What has the DPC said about what's on the horizon and what direction they're going to go now?
So the DPC has said that it is planning to engage and collaborate with the governing bodies and the organisations promoting sport in Ireland to develop awareness and to build knowledge of data protection in the sports sector, to ensure that sports clubs and sports organisations are better equipped to comply with their obligations under the GDPR, and ultimately to ensure that the personal data of club members, players and staff are protected.
Again, I'm hoping we haven't frightened the socks off everyone, but I suppose it is worth remembering that there is a conscious thing, particularly we see it in the courts, a conscious acceptance that there's a social utility with sport. So while I think the DPC is going to expect a kind of a greater level of compliance, I think that there will be a kind of a soft approach to that initially, but I think there's no doubt that as the sports sector gets more sophisticated, and that as even at grassroots level, more performance data is being gathered, and I suppose as clubs and organisations get more government grants, I think more is going to be expected in terms of compliance with data privacy rules. So take those first steps of the tips we've given today, and take those first steps. I think that's us finished with you, Micheál. Thanks a million for that.
Thanks, Rachel.
So the next thing we're going to do is turn to Nick, and something we've chatted about before, Nick, which is good governance. So hearing what Micheál and Catherine have said today, can you give us any kind of sense of what sports organisations can do on the governance side to try and deal with the issues that have cropped up today?
Yeah, sure. And sports organisations are no different in this way from any other kind of company or entity like that, in that there are people responsible for the operation of the organisation, and those people have certain responsibilities, but there are also certain tried and tested methods by which they can fulfill those responsibilities. So those people responsible, if the organisation is run through a company, they'll be the board of directors. If the organisation is an unincorporated association, as many clubs are, those people will be maybe known as the committee, they may be known as the executive, they may even be known as the board. I'll refer to them as the board for the purpose of this, by way of shorthand. And I think a couple of the themes which have come out of the very informative pieces from Catherine, from me, are that it's important for correct processes to be put in place, and it's important in a lot of areas for the correct policy to be put in place. And it's up to the board to do that kind of thing. And among the things they can do, and there are a few, but among the things I think are most important for the time we have here, one, the board should understand what their organisation does, and I don't necessarily mean by that what its ultimate purpose is. not necessarily running the football club. It's what does it actually do? What activities are involved in doing that? Does it employ people? If it does employ people, what kind of category of employer are there? If it doesn't employ people, are there volunteers? Are there consultants for to whom consideration needs to be given? On the other side, on from what Michal was talking about, does the organisation process personal data? Sounds almost certainly that yes, they will. But what kind of data is that? How is it stored? By whom is it stored? For how long is it stored? That understanding will enable the board to be able to further understand what they need to do. So if they do understand, they can then work out what policies they need to put in place. If they don't yet understand, then they need to put a process in place so they do, and the policies can come from that. And so the second element here is an understanding by the board of what their role and responsibilities is, what mechanisms they have at that they're given in order to to give better effect to how they do that. And really that'll come down in many cases to holding meetings as necessary as possible and holding them effectively. And then from that, maybe delegating authority to other people if the board identifies areas where either there is an element of expertise or a certain level of time commitment that they themselves can't have.
And there is a governance code. Is that relevant in the sports organisation context?
I mean, it is, and it's to give it its full title. It's called the Code of Practice for the Good Governance of Sporting Organisations.
Love a good title.
It is, and so I shouldn't have flipped about it because it's been in place for I think 5 or 6 years now. It is, as these things go, very helpful, I think, and a very good resource for boards of sporting organisations. It recognises that sporting organisations come in a wide variety of sizes, from clubs themselves up to national bodies, and also that sporting organisations are not all run through the same kind of structure. I mentioned companies and unincorporated associations already. They're the main kind. And what the code does is it identifies 5 principles and applies them to every organisation, but in different ways depending on the size of the organisation, which I think is sensible. And among those principles, all 5 are worth understanding, but the 2 which have most direct application to what we're talking about here are exercising control over your organisation and working effectively. And each guideline then has each principle has some sub-principles and some guidelines and some tips around that for how boards, depending on the category of their organisation, can best use their resources, best use what they have to ensure as much compliance as possible. And among those principles and guidelines are things like identify major risks and decide ways of managing them. That's what we've touched on already. Make sure the board is familiar with the organisation's constitution. And that means in the context of, in a company, will be called its constitution or its articles of association. For unincorporated associations, that may be called rules, may be called bylaws, but it's the governing document that from which the board draws its authority. Other sub-principles are to develop necessary policies. Again, that's direct application of what we're talking about, to take out appropriate insurances, and which is what I've already touched on, to hold regular meetings with sufficient notice and agenda and minutes to enable the board to be as effective as they can, given that certainly in volunteer organisations, time really is a premium.
And anytime we chat about kind of principles of good governance, we always come back to the issue of meetings. So, and the importance of meetings. So what is the benefit of holding meetings? And are there any rules around meetings that people should be aware of?
Yes. So the kind of default understanding at corporate governance is that the people who are responsible for taking decisions with the board, as we're calling them here, will take their decisions in meetings. And I'll use the example of companies because there is a Companies Act, there isn't an Unincorporated Associations Act. So company law tends to be better, clearer and better understood than otherwise. But the Companies Act, while it does give a couple of ways where directors and boards can take their decisions, it assumes that boards will meet to do so. And it's really the default. And That's because meetings are considered beneficial in that they foster debate, they enable better consideration, they allow for questioning, and they allow for dissent, which it can be taken too far, but it is important. You're not there just a rubber stamp, you're there to understand the decision you've made and to make as informed decisions as you can. On the flip side of that, of course, is, and I'm sure that many people who've tuned in today will know this from bitter experience, that badly managed meetings, badly run meetings are just a waste of time and resources, and can often be worse than that. In that they can foster, fallings out amongst the board, which is the last thing mistrust amongst the board members, which is the last thing you want. And so it's important that where boards do meet to take decisions, that there is a purpose and a structure behind them, that the board is given advance notice of the meeting, and if there are things that they should read before they go into the meeting, that they're sent those, they're given chance to do so, to consider what they need, so they can arrive at the meeting as informed as they can be. There should also be an agenda with which clearly sets out what the business is. You don't need to go into detail, but once you've done the agenda, it's important to stick to it, so that the meeting doesn't get derailed in things which are not necessarily relevant in the scheme of things, but are relevant for the purpose for which the board is meeting. And then there's an important role then for the chair of the meeting when the meeting is finally convened. Every organisation usually has a chair, and the chair's real only role is to make sure that the meetings of the board flow in the way they should do, and it is quite an important role to make sure that everything is discussed in a fairly efficient manner, but that there is opportunity given for people to ask questions, to say, have we thought of this, to say, I think this is a bad idea because. And finally, the idea behind that is that if a decision is to be made, that the decision should be made in the meeting. And by that, I don't mean that the agenda says a decision to be made to do something, and then therefore the board ultimately comes to that decision. What I mean is that a vote is taken and it's either passed or it isn't passed. Because if you don't do that, then all you've done is you've set yourself up for another meeting because you need to do this. So either this needs to be done or you're going to decide to do something else instead.
And you mentioned the concept or the issue of delegation by the board. Is that common?
It is, yeah, and it's vital that if a board is going to delegate, that it holds meetings. I just wanted to actually just to mention, you did ask as well about rules of meetings. I just wanted to go and just say that thankfully that there aren't that many rules around meetings, certainly not, again, in the context of companies, in the Companies Act. Boards are kind of generally assumed to be able to manage the affairs of their organisation efficiently without having to stick to strict rules. But it is important to note a couple of things. One, you have to give reasonable notice, and that will depend on circumstances, but you can't just call meetings on 5 minutes unless there's something extremely urgent to be done. And secondly, it's important to know as well that there is always a minimum number of people who have to attend the meeting in order for the business that conducts the meeting to be valid. The default of that is 2. With sporting organisations, it tends to be a bit higher because they tend to have less frequent meetings, and they tend to have individual members of the board who have specific roles within the organisation. It's important as many of them turn up as possible. And where that information will be held or found is in the club's constitutional governing body. So again, it's important to know about that. But on the subject of delegation, one thing as well that, and again, I'll use the Companies Act because it's there isn't an equivalent for unincorporated associations. But the Companies Act not only gives a board-wide discretion to delegate their powers to whomever they see fit, company law in general kind of assumes that they will. And that goes for other kinds of sporting organisations as well. And just to use some examples, a larger organisation, the board will need to delegate because that organisation will do so much in so many areas that the board can't really do it all themselves.
Yeah.
They have to identify individuals who will perform discrete tasks and do that on the organisation's behalf. And on the other side of the spectrum, smaller volunteer-run organisations, as I've touched on already, time is very precious for those boards. They have the day job, they have families, they have lives outside. Meetings are usually held outside of business hours, and so it's not important not only that those meetings are held efficiently, as we've touched on, but also that where there are areas which require a bit of expertise or require a bit of time intensity, the board make sure that there's someone, it could be one of the directors, it could be someone outside the board, so it's one of the board members, someone outside the board is charged with doing that. And just to use some specific examples from Catherine, from Michael's talks there, a larger organisation more often than not will delegate their employment matters to either their HR department or maybe to an HR manager who themselves need not be a member of the board. And smaller organisations, or in fact with all organisations, as Michal has mentioned, should identify an individual or individuals who focus on what data is being collected, how it's being stored, how long it's being stored, and are also there then to deal in the first instance with data subject access requests and data breaches if God forbid there should be any. And so having established that it is not only usually permissible, but also fairly kind of important that the boards delegate their authority, there are some not rules so much as guidelines around how they should do that. It's important that where a board does delegate to someone to do things on its behalf, that the delegation is clearly communicated and clearly understood, not only by the delegate, but by the board themselves. And the delegate needs to understand not only what they have been asked to do, but what they have not been asked to do, because you don't want somebody exercising the authority of the board where they have got authority to exercise.
Yeah.
The best way of doing that is to put it down in writing. That could be in a contract, that could be in documents which are called things like terms of reference or something like that, or it could be in, to follow up on themes of things that Catherine and Michal have been developing, in a policy. And again, to bring the circle back, policies are formed by the board through discussion, through meeting, through making decisions like that. And it's also important that policies are regularly reviewed, terms of delegation in general, regularly reviewed and updated if there are changes in the law or just in terms of things which are working and not working. And finally, there should be an ongoing level of communication between the board on the one hand and the delegate on the other. The board should be able to exercise oversight, if that's it, in just asking the delegate to come along to board meetings now and again to report on what they've been doing, if there's anything. And on the other side of it, if so the delegate needs to be aware that if there is something that needs to be brought to the board, it is brought to the board, and there are channels available for the delegate to do that.
And just, I suppose, returning to the issue of constitutions or club rules or rules of a sports organisation, how important is it that a committee would be aware of the contents of that, or where would they find it?
Yeah, it is. I mean, there's no need for a board necessarily to learn the constitution or the rules or whatever they're called by heart, but they do have to have a familiarity with it, at least, certainly, at the very least, as to how it affects them and their roles and how they fulfil those roles. And crucially, to be able to know, as you've touched on there, where it is, how they can get hold of a copy, they need to look something up. Because the Constitution, the rules, the bylaws, whatever we're calling it, will probably explain how a board meets. It will have the quorum in, which I mentioned before. It may touch on delegated authority, although that's less common. And the constitution for a company, that's easy enough. That's found that it's a legal requirement that every company has one, and that it files that the up-to-date a copy of the up-to-date constitution at the company's registration office. It can be obtained there for the payment of a small fee. Unincorporated associations, again, they're less formal, but there will be a copy of the rules, a copy of the bylaws, whatever, around. The secretary will almost certainly know where that is. If you are new to a board and you haven't seen that or you're unfamiliar with it, it's worth asking for a copy just to familiarise yourself with it.
As usual, Nick, a really helpful summary and a really helpful reminder of kind of good governance principles, because really everything comes from that. So thank you for that. And I'm going to do a mandatory time check. We have a couple of minutes left. So what we might do is we might just go back through all contributors and maybe get your top tips, your takeaways for today. So Catherine, will we start with you?
Yeah, absolutely. So I think the first top tip would be to carry out an inventory of your people. So make sure that everybody is classified as they should be. If there's a potential of misclassification, get that remedied, seek advice if you need it. Remembering that, you know, misclassification could lead to employment issues or tax issues. The second piece of advice would be with the influx of remote working requests to deal with those within the 4 weeks of receiving the request, or look for an extra 8 weeks if you need it. And then thirdly, it would be remiss of me not to mention policies. Seems to be the message of the day.
Word of the day.
Yeah. So do you need any policies implemented, whether that be remote working, protection disclosures, grievance policy? Make sure they're up to scratch. So that'd be my top tips.
And don't stick them in a drawer and forget about them.
God, no,
Review them.
definitely
Review
not.
them.
Yeah, yeah.
Thanks for that, Catherine. Micheál, your key takeaways from today.
The key takeaways are essentially the key findings from the DPC survey. So following up on Catherine's point, ensure you have policies and procedures relating to data protection, ensure you have a data retention policy. If you're processing performance data about players, then carry out a data protection risk assessment. Assess if you're processing special category data, and if you are, ensure you have a valid legal basis to process that health data or performance data. And finally, if your volunteers or staff are using their own devices, ensure or consider implementing a bring your own device policy.
Very helpful, Micheál. And finally, Nick.
Yep, sure. I'll keep brief. A board should understand what their organisation does and how they can how they're supposed to operate to best manage that. Hold regular meetings and hold them effectively, and delegate where necessary. But if you do, make sure that the lines of delegation are clearly communicated.
Fantastic, fantastic. And thank you all. That's been really, really interesting. I know it's very interesting from my perspective, so I hope it's been very interesting for the audience as well. So that's it for today. We were delighted to be here and we were delighted to present to you today. Do keep an eye out for our next webinar, which we hope will be in the next few months. As I say, we are doing this series of webinars focused at the sports sector. So if you have any questions, you can send them in to us and we will deal with them separately. We didn't have time for questions today. We knew the topics were fairly meaty and that there would be a lot in this, but do get in contact if you have any questions. And apart from that, enjoy the rest of your day.
Thank you.